It strikes me that maybe none of us were aware of this amazingly large loophole in the constitutional limits on the executive until COVID, where they just seemed to keep pushing the limit to see how far they could go, and there didn't seem to be any way to stop them, no matter how serious or unserious their proposals were.
Yeah, and I think that the two reasons in this case. One is that for the last not quite 100 years, but courts have just given vast deference to executive agencies and to the government in general. The rule when an issue doesn't involve, say, racial discrimination, in which case the courts will take a close look. If it's just a run-of-the-mill, so-called, like a land use regulation or alcohol regulations, courts will defer to the government, and in fact, the judges will even look for a reason to support the government's actions. It's called the rational basis test. And so if the court can come up with any reason that would justify the government's regulations, it will uphold it. So that's kind of the overall jurisprudence status where we are now, unfortunately. Obviously, one of the things Pacific Legal Foundation wants to do is to get that scrutiny increased, so judges take a closer look at these kinds of things. But the second reason, I think, in this case is because it was a pandemic. There were a lot of things happening quickly. We didn't know exactly what was going on. And in those kinds of cases, the judges are especially reluctant to second guess the executive.